Welcome, Rachel. Thank you for joining us. We're going to get going here momentarily. All right, well, thank you and welcome, everybody. We do have to get underway because our poor little nonprofit has one Zoom account and we have a meeting at 11, a different meeting at 11. So we need to move this along and get things going. There's going to be opportunity for Q&A at the end, but initially Jordan will just go through his presentation. So I will introduce Jordan now. Jordan Schwartz is a partner in Con Maciel Carey's National Labor Employment Practice Group. He focuses his practice on representing employers in all aspects of the employment relationship. Mr. Schwartz has particular expertise defending hotels, resorts, and inns against claims alleging lack of accessibility under Title III of the Americans with Disabilities Act, or ADA, and routinely is hired by property owners and managers to conduct on-site inspections of both the physical features of properties as well as their website to ensure compliance with the ADA. Mr. Schwartz also routinely advises employers on and defends employers against claims of discrimination and harassment, wage and hour violations under the the Fair Labor Standards Act, FLSA, misappropriation of trade secrets, breaches of non-compete agreements, and other restrictive covenants. Mr. Schwartz has extensive expertise in the hospitality industry. I can certainly attest to that. We really appreciate that he's taking the time today to be with us. He works on this on a regular basis and with several associations. So Jordan, I'm going to turn it over to you, and we will probably have people joining us as we go along. But thank you for being here today.
Oh, thank you very much for that introduction, Greg, and thank you for kindly inviting me to speak. Greg and I were just talking, and I was saying I really enjoy doing these presentations just so I can educate as many people as possible about the various ADA Title III issues that you may be aware of, you may not be, or you may have some dangerous working knowledge of, but not enough to be fully compliant. So what I'm going to do here, in the next 40 minutes is just try to give you a brief overview of Title III of the ADA, what that means, what are the things you should be thinking about, and then, after just a real brief overview, go into the actual website issues. That's the main part of this presentation. And there are two different website issues. And then if we have time, which we likely won't, I have a little bit of a service animal reminder. But even if we don't get to that, you'll have access to these slides, and at least these slides will give you some information about service animals. But let's just start with Title III of the ADA. The ADA is a federal civil rights law, and I have in this first bullet point here that requires all public accommodations to be accessible to individuals with disabilities. Often people think of, if you're an employer, you think of the ADA as you have an employee who is disabled and they need some sort of accommodation. That is part of the ADA. That's Title I. But what we're talking about here is public access. We're talking about guests, and we're talking about what features your property needs to have to accommodate those guests. And the ADA has been around since the early 90s. It became the law in January of 1992. And importantly, I have in this last bullet point here about what some people refer to as a grandfather clause. I have people call me probably about once a week and say, I just got a demand letter, or I got a lawsuit saying my property is violative of the ADA, but phew, I'm lucky that my property was built before 1990, so I'm grandfathered out. And I'm not sure where that rumor began, but please remember that is just not a thing. There is no such thing as a grandfather clause. It's tricky if your property was built in the 1800s, because certainly, many building features that are common in older facilities, you might have narrow doors, round doorknobs, just not enough space. But in some ways, you're kind of out of luck there, and you need to do at least what you can do to make your property accessible. You are not just exempt. There could be a certain slight exemptions if you're a historical property, but please note that if your property is older, that does not mean you're exempt. So Title III of the ADA, covers all what's called places of public accommodations. For everyone on this call, we're talking mainly about hotels and or restaurants. And, it prohibits you as a hotel from denying services and accommodations to people with disabilities. Of course, that doesn't just mean you saying to someone, you're in a wheelchair, we can't accommodate you, sorry. What it means, and I'll get to this next slide right here, is that you must affirmatively remove barriers to access. And of these 3 bullet points here, everything we're talking about really for this entire presentation is going to be number 1. If I was giving a full presentation on just the physical aspect of your property, I would talk about all 3. And the second one is you are required to modify policies, practices, and procedures. And arguably your website it falls under that as well. And also you're required to provide auxiliary aids for people who are hearing or visually impaired, such as potentially large print menus, braille, and even some type of interpreter services if requested. But that's more for a different presentation. But in terms of barriers to access, that would be if you have stairs in front of your property instead of a ramp. If you have a front entrance door that is heavy or difficult to open. If you have a public restroom in your lobby that is not ADA accessible, if you have a checking counter that is not ADA accessible, if you have guest rooms that are not ADA accessible, those are all barriers to access, and those barriers must be removed and or fixed to the greatest extent possible. The actual legal term depends on when your property was built, but the general legal term is you must make changes to the extent it is readily achievable to do so. And there's a whole host of litigation on what that actually means. But if a plaintiff comes to your property and says, I'm not welcome because I can't get to the front door, you're going to have a tough time defending, saying, it's not readily achievable for us to have a door that you as a disabled person can use. So really, especially everything that's open and can be seen by people from in the public, parking, front entrance, check-in, you really want to make sure is accessible. And then, of course, you have to deal with your rooms, and you want to make sure you have the proper number of rooms and then the proper features within the rooms. That is really all I'm going to say about the physical property aspect of Title III, because again, that was a brief overview, but you will see the second part of website accessibility actually dovetails into the physical aspects of your property. So there is a relation that you will have to realize and be cognizant of going forward. I apologize for my voice. I'm just a little bit under the weather, but hopefully you can still understand me okay. In terms of the ADA website accessibility, I get calls, weekly, more than weekly, asking if I can review someone's website to make sure it's accessible. First, before I say yes, I need to determine what are they talking about, because there are 2 different types of website accessibility. And really the cases, there's about 50% cases on one type and 50% on the other type. The first type is about your actual website and the code and the people who are making your website. And that issue is, does your website need to be accessible for users with visual and hearing impairments for the most part, so they can actually utilize your website? So that is what I'm going to talk about for the next 15 minutes. And there's a slightly more complicated answer, but at the end of the day, the answer is going to be yes. And then part two, the last 20 minutes of the presentation, I'm going to talk about what's still considered website accessibility, but the issue there is, does your website provide information regarding various accessible features at your hotel? And that's where it dovetails into the physical requirements of the ADA. And the regulations actually say that, yes, your website must provide that information. So I'll talk about each of them separately for a few minutes. First, we're going to talk about your actual website, the issues for users with visual and hearing impairments. So again, the question here is, must my website be accessible for those who are hard of hearing and hard of seeing? And the problem here is that there is no actual regulation that provides an answer to this. Again, the ADA was promulgated in 1992. They weren't thinking about whether a website needed to be ADA accessible. So all of the law and this part of a website accessibility has been promulgated by case law. And as you know, there are cases that come out all over the country, and some of them contradict with each other. So courts have ruled on both sides of the issue. And still, in 2022, there is no universally recognized standard for achieving website accessibility. I'll get to on the next page what the DOJ is saying now, but the DOJ has not actually promulgated regulations. They have provided guidance that and a standard called the Web Content Accessibility Guidelines. And that is the standard that most courts are saying you need to follow as a place of public accommodation. So again, I don't know the extent of knowledge of people on this webinar, but what we will need to, hopefully that one of the takeaways from this webinar will be for you to determine if your website called WCAG, if it is WCAG compliant or WCAG compatible. And I will get into that a little bit more in the next few minutes. In the last year, there were almost 3,000 web accessibility lawsuits filed in federal court. And that number just goes up and up every single year. And those are only federal lawsuits, and those are only lawsuits that are actually filed. There's still plenty of demand letters and plenty of informal settlements. So, the number is probably, close to 4,000. Just about a month ago, I believe, the DOJ, for the first time in over 10 years, it's been silent since 2010. And finally, it actually weighed in, and it says that we have consistently taken the position that the ADA's requirements apply to all the goods, services, privilege, or activities offered by public accommodations, including those offered on the web. So that is really a big deal that the DOJ just said this, because no one, they've really been silent all this time. But you also have to take that with a grain of salt, because this is, I emphasize the word here on the third bullet point, guidance. It is not a regulation. It is not the law. A court easily could rely on this guidance, or it could say, we've seen courts do all sorts of things the last few months. It could say, it's guidance, but, we're not really going to, it wasn't, promulgated for a comment period. It wasn't, it wasn't, the procedures weren't administratively followed, and we're not going to abide by that guidance. So we're really at this point not sure how forceful this guidance will be. So as a result, I have to be like a lawyer here. I try to not be as much like a lawyer on some of these calls, but I have to talk about case law a little bit, because there's really no other way to just give you a sense of what's going on in the law. It's just the way it is. So all of these cases, there were a few cases, there were a few issues before 2017, but it all really came to a front in 2017 when Mr. Gill, who I've defended against in several cases, sued a grocery store in the Southern District of Florida, Winn-Dixie. And he alleged that Winn-Dixie's website was incompatible with the technology software that assists the visually impaired, in violation of Title III of the ADA. And let me back up for a minute. I don't think I fully explained this in my earlier slide. When we're talking about website accessibility here, individuals who are visually impaired they have some sort of software on their own, what's called screen reader software, that will either allow a website to talk to them or make the font bigger or increase the contrast in the font. Basically, the screen reader software allows someone who is blind to be able to use a website. Now, from your end, your website needs to be compatible with this type of screen reader software. That is the essence of what we're talking about with an accessible website. You don't have to do anything specifically with screen reader software for someone who is visually impaired. You just need to make sure your website is compatible. So that is the issue 98% of the time in this first bucket of ADA website cases. And in this case, again, the customer alleged that the store's website was incompatible with screen reader software, and the court held that a website that has a physical store location, such as all of you on this webinar, who most likely, I am imagining, have a website that is tied to your hotel or tied to your property. The court held that a website that is tied to a property has a nexus to that property. It operates as a physical gateway to the property. And as such, that website is in and of itself a place of public accommodation, and it is covered by the ADA. The judge said a website might not always be a public accommodation, because remember, the ADA only applies to places of public accommodation. But the judge said in this case, the website was a place of public accommodation because it was tied to the store. Then we fast forward 4 years later, we don't hear anything from the court. Then in 2021, the 11th Circuit, and that is the court that oversees Florida and also, I believe, Georgia and Alabama. This court reversed the ruling and said, you know what, we are reading the ADA, and the plain language of the ADA doesn't say anything about websites. It is limited to places of the places of public accommodation is limited to actual physical places. Thus, because the website is not a place of a public accommodation, the website did not pose an intangible barrier to access. Remember, I used those words earlier. So right now, the law
my volume thing's gone.
Right now, the law in this jurisdiction of Florida, Georgia, and Alabama really is that websites do not have to be accessible. However, as I just mentioned, the DOJ just really said the opposite, and most people on this call are not in Florida or Georgia Georgia or Alabama. So important has ruled on this issue. And just real quickly, I'll get to a few other cases, and then I'll talk to a little bit more practicality. There's a case here in New York, a little closer to you guys, which it's from 2017, but it's relied on to this day. I just saw it relied on a few weeks ago in a case that the judge rejected the approach from Winn-Dixie and said that, you know what, even if you're not even attached to a store, even if you have a website in and of itself, you are considered a place of a public accommodation under the law. As long as you offer a direct sale of goods or services, you are on your own a place of public accommodation. So that completely contradicts with the Florida case. And then the last main case I want to talk to you right now, which was a huge case 2 years ago, was out in the Ninth Circuit, California, Oregon, Washington area, where a customer for Domino's tried to order pizza, couldn't do it because Domino's website was incompatible with screen reader software. And initially the court said, you know what, nothing in the law provides that you have to make the website accessible, but the Ninth Circuit reversed and said that Title III does apply to websites, and thus everyone in the Ninth Circuit does need to make their websites accessible. And interestingly, the Supreme Court, the plaintiff applied to the Supreme Court to hear this issue, and the Supreme Court denied cert, arguably effectively rubber stamping this decision. People can argue that both ways, but at the end of the day, the Supreme Court is going to have to, weigh in on this circuit split to figure out, what the actual law of the land is going to be. But now let's move into practical consequences here. What does this mean? What are the issues you should be looking for on your websites? A huge one is menus in PDF formats. There are a few plaintiffs that are going around the country right now and basically looking for properties, restaurants or hotels that have menus in PDF formats on their website. And if they do, they're bringing lawsuits. It's not always, but for the large majority of cases, PDFs are not compatible with screen reader software. So if you have a menu that's in PDF format, it is more likely than not that someone who is visually impaired cannot view your menu, and thus you are violating the ADA. So that's something easy. Everyone on this call today can see, should know whether or not you have menus on your website in PDF format. Other things, if you have pictures or symbols or maps or diagrams with no, written descriptions, at least, or at least descriptions that are embedded beneath the graphical image, so that a screen reader can speak the alternative text while sighted users see the pictures, that's a problem. The next one I've written down that people don't realize, requiring navigation only with a mouse. If someone is trying to pay for a reservation on your room, on your website for a room, and you have to click here at the end with a mouse and not use a keyboard, that is violative of the ADA. And the reason is the WCAG, the ADA, it requires the user to interact with the page using either a mouse or a keyboard, because for the most part, blind users can't use a mouse because manipulating the mouse is actually a visual activity. It involves moving the mouse pointer from one visual spot on the page to another. So you need to make sure that you have the functionality for keyboard use as well. And I guess, yeah, this slide is really just the flip side of the prior slide. You need to make sure you provide what's called alt text alternatives for non-text content. You need to provide captions, text captions for audio content. You want to avoid using color as the only means of conveying information. Again, make all functionality available from a keyboard interface. And ideally, you want to provide a way to pause or slow down certain features that sometimes time out of websites. There are ways to proactively test your website's accessibility on your own. There are some, Google free inspectors you can find, and this is a few of them. However, I really probably should delete this slide because this could help, but it is not enough. You really need human testing to make sure your website is compliant. If some of these free tools tell you you're not compliant, you're definitely not compliant. But if they tell you you are compliant, it's kind of like a fault. It just doesn't do enough. So, what you want to do is, this is actually the reverse order. I'll tell you on the next page how to help determine if it's accessible. But if it's not accessible, basically all the slide says is you need to come up with a remediation plan. If you don't have buy-in from the highest levels of the management and ownership group, you need to get buy-in so you guys can come up with a plan to make your website accessible. And I'm going to skip over this slide. And the main thing that really the only way to do it is to retain an accessibility consultant. And if you need, I have people I work with who I can, give you names of people who are very good. They're not always cheap, but they are the only ones who can really at least work with your IT team and give guidance or do it on their own, depending on what you need, to help make sure that you have a fully ADA compliant website. And the other thing I would urge, if you do that, you also should retain counsel, someone like me. It certainly doesn't have to be me, but someone who at least knows a little bit about the ADA. And it does not have to be expensive. The counsel doesn't need to be intimately involved in everything going on with your website remediation. However, if you don't retain counsel and you just hire an accessibility consultant, and then you get sued, the first thing a plaintiff is going to do is ask for all your records, and they're going to see, oh, you hired an accessibility consultant. What did the accessibility consultant tell you? Oh, look, he told you all the different ways your website is not ADA compliant. So that kind of shows them the roadmap for a successful ADA claim against you. But as long as you have a counsel who can be tangentially involved, and if you sign a contract with the ADA consultant, the contract can say, we are signing this contract under the advice and direction of our counsel, then all of the records pertaining to the accessibility consultant will be privileged, and you will not have to turn them over to a plaintiff's attorney. Just know this is something else I always want to make sure to tell you. I've had plenty of clients who have been sued multiple times by different plaintiffs for the same ADA violations. And, this comes out of a lawsuit where a company tried to defend against it and said, hey, we just got sued recently and we settled and we're in the middle of fixing our website. And the court said, you know what? Too bad for you, but just because you're settling with another plaintiff, that doesn't deny other plaintiffs their right in court. So really, what I try to do when I settle a case with a plaintiff is I get as much time for the hotel to become ADA compliant as possible. Sometimes I get 1 year or even 2 years because sometimes it takes a while, and I don't want you on the hook for a breach of contract claim if you are not able to fix the website as quick as you want. So I get you as much time. But on the other hand, to the point of this slide here, I also urge my clients, I know you have 18 months with this one specific plaintiff to fix the website, but you should do everything you can to fix the website as soon as humanly possible. That is the only thing that can really fully protect you from any legal exposure from any other plaintiff besides the one who already sued you. So it's really important to just be proactive and take remedial measures as soon as you can. And this is the case that talked about that. I'm going to go over that. This is something really important and should be really easy. So if any of you, regardless of what your status is right now in terms of ADA website accessibility, I would urge you to have an accessibility statement on your website. And it's really, it's one or two paragraph or 2 or 3 paragraph statement. I help clients do this all the time. It usually takes me like an hour. It is not a long thing. Basically, all you're saying is, we are doing our best to make our website compliant. These are the steps we have taken. If you have any questions or concerns, please contact us at the following contact information. On the next slide, I have a case, and I'm not going to go into it now because I'm already running out of time. But there have been cases, and it was actually in the New England area, the case that someone sued, and the court found that, you know what? There was information provided on the accessibility statement. You, Mr. Plaintiff, did not actually read the accessibility statement. That is your fault. We're going to find against you and in favor of the property. So just having an ADA accessibility statement may reduce your legal exposure. Here is it's actually in New York. I'm sorry, I thought it was in Massachusetts. When I send you the slides, you can look more at the details of that case. Okay, I'm going to take a quick breath here, and that was the information you needed, the real brief, quick information about the first bucket of ADA website accessibility issues. There are a few questions in the chat, but I'm not going to look at them yet. I'm going to save them for the end because I want to spend the next 10 to 12 minutes or so talking about this very important second part of the ADA website issues, and then I will get to your questions. And this deals more with website issues for users with mobility impairments. And this is very different than the others in that this is based on the ADA regulations. This is not based as much on case law. So it's very easy to follow what you need to do. So this only applies to hotels. If any of you on this call are only restaurants, this actually doesn't apply to you. But there are a few bullet points here under the ADA regulations, and the last one will be the most important, but I'm going to go through each of them with you quickly here. 1, you need to make sure anyone can make a reservation for an accessible guest room on your website. Usually, properties are getting pretty good at this now, but as of a few years ago, properties might say, oh, if you need an accessible room, you can book a non-accessible room on the website, but if you need an accessible room, you need to call our main number. That is violative of the ADA. You need to be able to make sure someone can make a reservation during the same hours and in the same manner as individuals who do not need accessible rooms. Number 2, you need to ensure that accessible guest rooms are held for use by individuals with disabilities until all other guest rooms of that type have been rented. So let's say you have 10 rooms with a king bed and only one of those rooms is accessible. If the first person, on your website just books a king room and does not specifically request an accessible room, do not just, this is our biggest room is accessible, so we're just going to give away that room. that again violates the ADA because you need to save that room in case it's specifically requested for someone who needs it. Again, once all other rooms have been booked, of course you can book it. You know, you don't have to leave out rooms from your inventory, but it's just the order in which you're booking rooms. The third and fourth here are the subject. It's not of a lot of litigation, but I've seen it many times, including a case I'm on right this second. It's the cause of litigation. It's someone needs to be, when someone reserves a specific type of guest room, the hotel needs to ensure that that guest room that is requested is blocked and removed from the reservation system. And what happens here often is someone with a disability reserves a specific room. Let's say they really need a roll-in shower. Then for whatever reason, I'm sorry, I'm just going to take a drink of water here. Then for whatever reason, that room is given away to someone else. The individual comes to the property and someone behind the front desk says, "Oh, I see you were in an accessible room. We gave that one away, but no problem. We have another accessible room. You know, I'll get it for you right away." That person gets to the new accessible room. Oh, there's not a roll-in shower. It's just got a tub with a seat, which is an accessible room, but it may not meet this individual's needs. So A, this is the law, so you need to follow it. And B, from a practical standpoint, following it takes some of the decision-making out of the hands of your front desk clerk, who you don't want to be put in a situation where they're trying to evaluate, or even not evaluate, but communicate with an individual about his or her needs, and trying to decide what best meets her needs. The person who made the reservation is the best person to decide what their needs are. And similarly with number 4, if someone reserves a specific room, if someone with a disability stayed in room 513 last year and it met their needs perfectly, you don't want someone, and then they reserve it again, you don't want them to get to the property and then say, "Sorry, we don't have that, but we have another one that may or may not meet your needs." Again, I'm in a case right now where they were put, the hotel had an outdated chart, and they were put in not only a room that didn't meet their need, they were put in a room that didn't meet their needs. And now there's a whole issue that could have been avoided. So this is really, really important, and it's really important for you as a hotel to recognize that there are different types of ADA rooms. There are some with roll-in showers. There are some with tubs. There are hearing impaired rooms that are different than mobility impaired rooms. So that's really important to know. And then this is the final prong of the regs that is the most heavily litigated, and the main issue in this website accessibility second bucket. Your website must identify and describe accessible features in your hotel and in your guest rooms in enough detail to reasonably permit someone with a disability to independently assess whether the hotel meets his or her needs. So, as I said, this final prong of regulation, is subject to thousands of lawsuits. And what people do is they sit at home, they go through websites one at a time, and basically they look, if you have a bullet point list of the accessible features of your property. And if you don't, they're going to bring a lawsuit. And this is what I was saying about how this website accessibility issue dovetails into the issue of your accessible features actually at your property. It's really hard to say what is enough information. The regs say sufficient information. There is no bright line rule to determine what is deemed to be sufficient. But when you do this long enough, you just see what courts have really held to be enough information or what courts have held is not enough. So at a minimum, you want to or accessible entrance. Anything you think about someone coming to your property, what would they want to know? I urge you just to take a step back. When we're talking about the first part of website accessibility, that is hiring an ADA consultant. That is doing code on your website. That is difficult. We really want to improve it, but that can be time consuming and costly. Coming up with a bullet point list here is not that time consuming. It's like the ADA accessibility statement should only take an hour or two. This really should only take a few hours. So I really urge you to, if you don't have some sort of list, providing all of the accessible areas. Is your restaurant accessible? Is your lobby bathroom accessible? Is your check-in counter accessible? I urge you to provide that. You want to be careful. You don't want to provide wrong information, because then someone could come to your property and not actually have the features that they thought, and that could result in a problem. But you do want to provide as many examples as you can. And if you need, I'm happy to help you come up with some sort of list, so we can get your websites in good shape if they're not already there. The law arguably says that you should provide a list of what is not accessible. I don't quite love doing that, because that really, it's kind of, you're damned if you do, you're damned if you don't. The law says that, but then a plaintiff will have a little bit of a roadmap to suing your property for lack of physical ADA compliance. So I don't love doing that. And then you need to provide sufficient information regarding the accessibility of your rooms. So for your accessible guest room, you want to, provide number of beds. Is it a king? Is it a queen? Is it a double? And often I know properties, let's say you have 4 accessible rooms. Sometimes properties only provide king rooms because you have more space. I'd urge you to try to provide at least 1 room with 2 beds. And I'll get into this a little more in the next slide. But 1, the rooms are required to be dispersed, and that's what's on the next slide. But 2, someone in a wheelchair often travels with a companion, and people don't think about this that much, but the companion may not be their spouse, and they might not want to sleep in the same bed with their companion. So it really would be ideal to have at least 1 option with 2 beds. But back to the website, in addition to explaining the number of beds, you want to explain the type of bathroom. You want to say if it's a tub or if it's a roll-in shower, if there are grab bars. And you want to, again, ensure that a guest can reserve the accessible guest room online. Either one with a roll-in shower, one with 1 bed, one with 2 beds, one with a tub, etc. And to this dispersion issue, there's a number of cases. Recently, a lot of the cases are whether they just sue, and I see the same plaintiff saying, 1, that I didn't even talk about here, that you don't have an adequate loading and unloading area in front of the property. That's a whole different issue, but I see the same plaintiff alleging that you don't have a proper loading zone. And then he says, even if you do, your guest rooms are not adequately dispersed. And what that means is, what the law says is you must provide people with disabilities choices of the types of guest rooms, number of beds, and other amenities comparable to the choices provided to other guests. So if you have some double rooms, some king rooms, some suites, for guests that are able-bodied, you should have at least 1 double bed, one king room, and one suite available for someone who's disabled. It's, if you don't have a suite, it could arguably be discrimination that someone who's disabled is only relegated to the lowest class of room at your property and is not able to reserve a suite. On the other hand, if you only have suites for someone who's disabled and they just wanted a regular room, you should certainly allow them to be in a suite, but you shouldn't charge them the suite rate. You should just charge them the rate they would have gotten for the regular room. And I want to leave time for questions, so let me just finish with the last point here. And these are the other slew of lawsuits, and they probably annoy hotel owners and operators more than any other. And this is with the OTAs, the online travel agencies, the Expedia or the Orbitz. You need to be really careful because these lawsuits are now suing you. They're suing the hotel owner and operator for, let's say, Expedia, for Expedia's failure to provide accessibility related information about the hotel, or its failure to allow a guest to reserve an accessible guest room. Common sense dictates, wait, that doesn't make sense. This is Expedia's fault, not ours. But the hotel regs say these lawsuits can only be brought against hotels, against places of public accommodation. Expedia or Orbitz is not a place of public accommodation. So it is critical, if you sell rooms on these sites, to review those websites and ensure that the bullet point list that hopefully you have, or me or someone like me can help you put on your website, that is also put on Expedia's website or Orbitz or whatever other OTA. It is your responsibility to at least show that you provided that list to them. Otherwise, unfortunately, you are on the hook for these lawsuits. It is not them. I get such frustrated clients with this, and I share the frustration. But this is kind of a loophole that some plaintiffs' attorneys have found, and they are able to successfully sue properties due to these OTAs failures. So again, this is just something to please keep in mind, and I can help you more going forward if you want to talk about it. We're going to skip the service animals right now. As I said, if there's specific questions, we can talk about it. I have a whole webinar series at my law firm. If you want to, listen to any other webinars, in a few months, there's the ADA on September 21st. There's ADA compliance for your property's website. If you want a refresher on any of this, here's a blog, all different blogs from my website for you to follow if you want. And here's, any questions you have. And with that being said, let me go right now to the chat. And here's my contact information if you want to reach out with any questions, and let me go see what questions you have already asked.
And anybody that wants to raise their hand as well, because they have a question, please feel free to do so. I would like to take this opportunity, Jordan, to thank you. I know you're not feeling well. You could have very easily not done this, and we appreciate the fact that you toughed it out and did it, so thanks. Do we have any questions?
And my pleasure, Greg.
Okay, yeah, there's something coming in on the chat, Jordan. Can you see that?
Yes. And the question is, I don't know if everyone can see it, so I'll read it. Do you have an opinion on website widgets such as AudioEye that hotels can pay $50 a month or something for? Yes, and my opinion is not great. I tried to mention this earlier. I might not have used the word widgets, but that is what I was saying. That there may be some that are free. They could be a good starting point, just so you can see get a general sense of the sufficiency of your website, but they don't provide enough. And I actually have an ADA consultant who's told me, I don't know if this is true, but he's told me that some plaintiffs actually look on websites to see if there are widgets and might even target those websites because they know they are not sufficient. And if you have it on your website, they assume that's all you're relying on. And there's really no substitute for human testing and someone actually going into the code and testing. These widgets do a cursory job. So sure, for $50 or one time to at least just get a readout, because it'll definitely tell you if you're not accessible. But if it says your website's 100% accessible, I wouldn't fully rely on that.
Any other questions from anybody? Either throw them in the chat or raise your hand. Oh, here we go. There's more on that original question, Jordan.
Okay, yes, I just saw it. Thank you. Can you recommend someplace online that has a list of what is necessary to remediate your website if you wanted your own web designer to do it? I don't know that. What you can Google, WCAG, it's WCAG. The latest version is 2.1. I think they're in the process of 3.0. And that stands for Web Content Accessibility Guidelines. And, it's kind of foreign to me, but maybe your web designer would be able to look at that and figure out what to do. But other than that, I do not know. Someone asked me the other day, I was actually walking through a property and they said, oh, can you please just send me, kind of a list of the ADA features I need to, have in my property, make sure it's ADA compliant. And I said, no, there's hundreds and hundreds of pages of the ADA. I can tell you what is and is not ADA compliant, but there's not just some little, bullet point list for a physical property. And I don't know if there's one for a website either. I have another question here. I have 2 suites in a 30-room hotel that are not accessible by wheelchair. It's by stairs only. Is this a problem? I need to speak more specifically, but assuming you have at least 1 or 2 accessible rooms and then you have 2 suites that are non-accessible, under the dispersion issue, it's not great. You're essentially telling someone, and I don't mean to be accusatory, but a plaintiff would say, oh, you're telling me, I'm not able to utilize one of your premium rooms. On the other hand, if it's accessible only by stairs and you don't have an elevator, and if it's too burdensome to get some sort of ramp, I understand that. It's not the big, out of everything I talked about today, it's not the biggest risk. But it most likely you have 2 suites and it would be ideal if one of them was accessible. So, maybe you can talk to your architect or someone if there's any feasible way to have it either some sort of ramp, or in the future, can you plan on adding a suite on a lower floor? Just to come up with options. But under this dispersion issue, technically a plaintiff would say you are violating the ADA.
Sorry, Jordan, can you hear me?
Yes.
Yeah, this is Gerard about that question. Those 2 suites are located in a building that was built in 1810 and physically not possible to get any access to a wheelchair. It's not a historic building, but it's an 1810 house.
Well, yeah, and that I get that, and so that's what you always want to just try to think about creative solutions. Is there any way in the rest of your 30-room hotel that at some point, doesn't have to be today, but you can have a plan for maybe making one room a little bit bigger. That could also be considered a suite, or at least a junior suite, or something, just to try to provide some sort of, if it's not equivalent, close to equivalent experience for someone with a disability. But I certainly understand the logistical issues and
There, oh, yeah,
have
there,
some
Jordan.
sort
Okay.
of, you
Kind
know,
of froze up, at
some
least for
sort of
me.
benefit.
Sorry.
Say that again?
You kind of froze up. It may have been just me, but
Oh, sorry. But I was just repeating myself. Just see if you can do anything in the rest of your hotel to give, if there's any other way you can make one room a little bit bigger, or provide some sort of suite experience in the rest of your hotel. So there's some sort of what's called equivalent facilitation. If it's not
Okay.
possible, it's not possible.
I do have 2 other suites, but not as nice as these, but I do have similar 2-room suites on the other side accessible. So I guess that should be-
Okay, that's that. Then at least you can say, yeah, we have someone who's in a wheelchair can reserve a regular room or a suite. Then I think you're, for the most part protected. Is it 1,000% safe? No, but all this is about reducing your exposure. Nothing under the ADA is ever about 100% eliminating your exposure. So I think that is okay.
Thank you.
Okay,
So,
Greg, we're
Jordan-
running up on the deadline here.
Jordan, can you speak just very briefly to, having, like I always tell people that they need to do an assessment, or have actually somebody do an assessment of their property and identify what potentially could be things that are not ADA compatible, some of them with, that are readily achievable, others that are not. And that they basically, as you just suggested, Gerard, basically have a plan and write up, we're not able to do this currently. However, when we do X, we may be able to modify that. Can you speak to that? Is that a good thing to have?
Oh, it certainly is. And, I'm biased because that's what I do. And half the times I do those, on-site inspections, it's after a lawsuit was filed. Not even half, maybe 2/3 are after the lawsuit was filed, but 1/3 is before a lawsuit was filed. And I think everyone I've ever done it for is extremely, and I'm not saying it has to be me, but is extremely happy with the proactive nature of that, because then if you eliminate all the common barriers, I can't say it's impossible you'll get sued, but again, it's reducing your exposure, making it more unlikely. And the same thing with websites. And quite frankly, between part 2 of the website, and that goes hand in hand with an on-site visit. And I actually have surveys I send out if I don't go in person. So at least the GM can do some things on their own and then send it to me, and I can at least help with the website part of it. But no, having an online an in-person ADA inspection, either with an attorney like me or someone else who's ADA compliant, or an ADA consultant, although I encourage an attorney also, so it's privileged, is extremely important and really can help. Just make sure all your ducks in a row, because these websites, as you know, and I don't know if people on this phone, and plaintiffs can demand the sun and the moon. So it's really nice to be proactive and avoid that. And do everything you can to avoid those lawsuits.
Can you quickly, because we have run out of time, can you address Kathy's question that's in there, that maybe that's something you can do quickly? I don't know.
Yeah, I'm sorry. I'm sorry, Kathy. I do not know any specifics about that. I can look into it and let you know, but off the top of my head, I just do not know.
All right. Well, thank you, Jordan. And again, we have that other meeting backing up on us, so we're going to be signing off and saying goodbye. But thanks again, Jordan, for taking the time today. It was very, very insightful. Thank you.